Welcome to One Happy Lawyer, the estate planning podcast.
Welcome to One Happy Lawyer, the estate planning podcast with attorney Dan Krause, founder of Krause Estate Planning and Elder Law Center in Wisconsin. Dan has been practicing estate planning and elder law since 1999 and is a board-certified estate planning law specialist. I'm Lisa Mosbey, and in this episode, we'll discuss having a will, a trust, or both. Welcome, Dan. Thanks so much for joining me in this conversation.
Lisa, I am always happy to see you, and the One Happy Lawyer is very happy today.
Excellent. Dan, can you explain what a will versus a trust does for us in Wisconsin?
So a will is typically just a document that says, this is what I want to have happen after my death. And it can say who gets your stuff. It can also say who's going to be in charge of any minor children. And it's just a what just in case you pass away. Now, we all know we're going to pass away eventually. So the will is really important to have before that happens. A will, though, it's really important to know that a will is a probate document, which just means that the will really has no effect until it is brought into the court. They open up a court case, and then the court looks at the will and says whether or not it's valid, and then the court supervises all of the stuff that's supposed to happen under the will.
And I know many estate plans include both of them. What job does a will handle versus a trust does not? Does that make sense? And what can a trust accomplish that a will cannot?
Great questions. So we know what a will is. A will is a document that gives instructions for what's to happen after death. A trust also can give instructions of what's to happen after death. A trust, different than a will, can also be utilized during the lifetime to give instructions as to what's to happen to assets. But when you're comparing the two, you're just comparing the end of life or the after death actions of the trust. Now, a trust can do just about everything that a will can do. Now, one thing that a trust doesn't do that a will can do is appoint a guardian for the children, minor children. That has to be done in a will. Other than that, a trust can do all of that stuff. And the nice thing, a really great thing about a trust is that it doesn't have to go through the probate process. And there's a lot of advantages to that fact that it doesn't have to go through probate.
And Dan, we so often see both of them used. In what kinds of situations can a will be a solid fit without adding a trust?
In most cases, we find that a trust is a better option. However, a trust does cost more. Setting up a trust, if you're going to do it with a professional, it costs more than just setting up a will. Now, one thing that I didn't answer in your last question is that every time you have a trust, you should also have a will. There should be no estate plan without a will. A will is a backup, a backstop, just in case things are not handled by the trust. It sometimes happens. But most of the time when you have a trust, you can just toss the will after the death and you don't have to worry about that.
And then what circumstances tend to lead someone toward a trust-based planning situation versus the will alone?
Now, I did have one client in my 26 years of doing this that said, I really want a will. I don't want a trust. It's not the expense. It is the fact that I don't trust anybody that is in my family to make sure that this all happens without supervision. I want the court to supervise because I think things are going to go wrong. But other than that, the reason that people choose a will over a trust is the cost. So what's the difference? It's essentially the cost of the plan is going to be slightly higher in a trust-based plan. Also, the trust is going to be able to get you out of the probate, which I think is becoming more and more important. The probate really digs into the ability of your family to have a privacy after death, because a will is administered in the court. The court is a public proceeding, so all probate documents and all probate proceedings are public. Now in Wisconsin, we have this program online that's called CCAP, C-C-A-P. And if you Google it, I think from anywhere in the world, if you Google CCAP, you can look at all of the cases that happen in Wisconsin online, and you can search for probates, and then you can find out who's died, how much they had when they died, and who's going to get it. And you can look at names and addresses of all the interested parties. And then if you are a scammer or somebody that has bad intentions, you might try to target those people whose names and addresses you'll find right there on the public record, and you'll know how much they're going to get. As to it's not a good idea to have your finances put online and to put in a public area for people to look at. But that's what happens when you go through a probate. So we don't recommend a will, primarily for the reasons of privacy, but also it's also more expensive, and there's more headaches administering an estate if you not only have to go to the bank and change the bank accounts and then retitle the real estate, not only have to do that stuff, but also have to file out all the court documents and appear in the court proceedings and follow the court deadlines and make the court announcements in the paper, and everything becomes public. So the difference between a will and a trust, there's many differences after death. During lifetime, the difference between a will and a trust is once you're done, you stick them both on the shelf and review them every couple of years. So there's not a lot of difference during life. It's after death when things become so much easier with the trust. It's really for the next generation. It's not for you to spend that little extra money.
And Dan, I think I didn't know about the privacy piece of it, or that the public can search for those things, and that you're kind of opening yourself up to the spammers or the people who are unethical. Do most of your clients realize that that is the case? I don't know that the general public thinks about the public events that happen with a probate.
So that's a really good point, and it's something that I've been proselytizing about for some time now. I do weekly seminars that we invite people to come to in different communities throughout Wisconsin every week. And I always tell people about this because, like you say, people don't realize that. If your stuff's going to go through probate, back in, say, the early 2000s, maybe the privacy wasn't that big of a deal because everything was done on paper. So somebody would have to, you couldn't have somebody in North Korea searching your information. CCAP, the website for the Circuit Court Access Program, didn't exist at that time. It was just in the baby phases. But now anybody in Uzbekistan, North Korea, whatever, they can look at the probates that are happening. So as AI and web bots and chat bots crawl the internet looking for money, because a lot of people that have bad intentions, when they're out there, that's where they can find money. And so just back to your question, if people don't know, that's why I talk about it. I want people to know about this. It's not that the courts are evil, but in this case, they can facilitate evil people looking for your family's money.
Right. How does incapacity planning work differently under a trust compared to a will?
So a will only applies to anything that happens after death. A will has no application to anything during your life. So it has no ability to help you plan for incapacity. It is only an after-death document. A trust, however, like I said, it's active during your lifetime. We just talked about what it can do after your death to make sure that people get the right stuff and all of that stuff. But if you have a trust, if you have a revocable living trust and you become incapacitated, there are provisions in the trust, or there should be, that says if I become incapacitated, then my successor trustee takes over and starts managing all my assets, my house, my bank accounts, all of that. So it allows somebody else to manage those assets, so you don't have to worry about a guardianship or somebody else coming in and having to take charge. It's the person that you've named in your trust. No matter whether you have a will or a trust, you should always have a proper and very comprehensive financial power of attorney. The financial power of attorney can do stuff that even the trust can't do. So when I said that the trustee could step in and manage your bank accounts and sell your house if need be, etc., They can, because those things should be owned by your trust. Once you set the trust up, you want to transfer your real estate into the trust. You want to transfer your bank accounts into the name of the trust so that you still manage them as you want. You use them as you want. You do your taxes the same. However, that allows the trustee to step in immediately and start managing them if you become incapacitated. The power of attorney, when you have a will, allows the people that are your power of attorney agent to do the same thing as long as you have the proper power of attorney. However, with the trust can only manage things that are in the trust. So let's say somebody had to call the Social Security organization, Social Security Administration on your behalf. Then with the power of attorney, they could do this. But your Social Security, your Social Security personality or persona or your account is not in your trust. Your relationship with the federal government is not in the trust. You can't put it in the trust. So you need to have somebody that's allowed under a financial power of attorney to do those things. So even though trustees have some control over your assets, they don't have full control over your whole financial life without also being the agent under a power of attorney. Almost always your trustee, your successor trustee, is the same as your agent under a financial power of attorney, and that unifies all the control of your finances if necessary.
So we have the trust, the power of attorney. Let's talk a little bit about what some of those other documents are in a trust that the will does not really manage. Are there things like power of health attorney, HIPAA forms, or other kinds of documents that would be part of that trust so that it functions during living and after death?
Great question. So, Lisa, I just want to make something clear that a trust is not a stack of documents. A trust is one document in itself, but the estate plan includes the trust and the powers of attorney and the will and the healthcare power of attorney and the HIPAA and whatever else you want to put in there to manage your assets. So assets or your healthcare, etc. So yes, some of the other things that you need in your estate plan are the healthcare power of attorney, and you mentioned it right there. The big three, or the big four really, are revocable trust, a will, a financial power of attorney, and a healthcare power of attorney. If you have all of those and they are properly drafted, you have a pretty good estate plan. Now, you also mentioned the HIPAA waiver, but before we talk about that, I want to talk about what we call a living will, or a declaration to physicians, or declaration to healthcare professionals. And in Wisconsin, that is the document that says pull the plug in case I'm in a certain condition, or don't pull the plug. You can indicate either way. Most people say pull the plug, and that's their pull the plug document. So the living will is very important as well. The HIPAA waiver is another healthcare document that says, if I'm unable to give permission, I hereby give permission to these folks, and you can list them, to access my healthcare information or to talk to my doctors and nurses about my condition. Because normally, if your child might call the hospital and say, can you give me the results of this test for my mom or my dad? Can you tell me how they're doing? Can you give me the updates? They can only give you a certain amount of information because of the privacy laws. If you've signed a HIPAA waiver that lists certain people on there, then any of those people should be able to call the hospital or a clinic and ask about your condition and get your medical records. So that's also a very important document during your lifetime. Some other documents that people use as part of estate planning, sometimes we use irrevocable trusts. And those are trusts that it's very hard to change, and you don't have full control of them anymore after you create them. So they are used for asset protection. We most commonly use them to save the house and save the life savings against the cost of nursing care. So if we put assets into a special, or not a special needs trust, but that's another kind of irrevocable trust, an MAPT, a Medicaid Asset Protection Trust, if we put those in there and we wait for 5 years, then the assets that are in there do not have to be used for a person's long-term care. So we use irrevocable as well as revocable trust. Sometimes we use LLCs or business structures. Sometimes we use partnerships. in order to put assets in there. There's certain tax advantage to using those sometimes, and sometimes it's a great way to manage a business as it passes from one generation to the next. We also use marital property agreements, which can be in the form of a prenup, or which happens before marriage, or a postnup, or just a marital property agreement where two people who are married say, we agree that this property is yours and yours alone, and you can do what you want with it at your death, and this property is mine and mine alone, and I can control it, and you can control assets like that, specifically, and often very helpful in a second or third marriage situation, to keep those things separate, to make sure that one spouse's children don't get disinherited at the first death, etc. There are other
Dan, there are many
documents that we use.
nuances.
I'm sorry,
Yeah.
Lisa, I'm going on and on,
That's
but there's just tons of documents that you can use, and it depends on your situation. There's many, many documents that you can pick and choose from. Our general trust-based estate plan have about a dozen documents for an individual.
And I know we'll be getting into each and every one of those documents and what is included in future podcasts.
I just
You know,
get so
what are the
excited. I can't stop talking about that.
I can tell, I can hear it. I'm like, oh my goodness. This is a person who's passionate about his job and passionate about how he serves people and takes care of his clients. Just a quick touch point on costs. You know, there's all these different documents involved in estate planning. Just the cost comparison between a will and a trust. You had mentioned a trust is a little more expensive. Ballpark it, like how much more expensive, and should people really seriously consider that because of that public aspect of the will having to go through probate and people knowing your business?
So that's a great question. Now, you can get estate plans for nothing. You can even have ChatGPT write you stuff. I've looked at that stuff, and I wouldn't really recommend that. In fact, self-help estate planning, we've made lots and lots of money helping to try to clean up those messes afterwards. We'd rather see somebody have a good plan up front that they don't have to worry about, plus doesn't make a mess for people in the back end. So there is the zero cost estate plan. In fact, even if you do nothing, and we see this all the time, people do nothing during their life, the government has already set up an estate plan for you. But we find that the self-help estate plans and the government estate plans actually cost more than doing estate planning with a professional, because in the back end, your family is going to have to sometimes spend down your entire estate on nursing home. Sometimes the tax, the things that you're trying to do to save assets cost your family on the back end with taxes, sometimes fights, sometimes government claims against your estate, etc., because people don't know exactly what they're doing. So the government has a plan that doesn't cost you anything. You can do your own plan that doesn't cost you anything now, but may cost you quite a bit later, or you can do professional planning. So with that said, the difference between a will-based plan and a trust-based plan, and it depends on the plan. We've got several different plans at different price points. But when you jump from the will to the trust-based plan, it's about $1,000 difference. Now, estate planning is not cheap. And if you look at the whole picture, it's really not expensive either. But it's planning now, it's paying now for a benefit later for your kids, essentially.
Very well said. And I'm going to leave it right there. For $1,000 in difference, it's definitely worth considering looking at a trust and how it protects you long term while living and after death. Dan, thank you so much for your time today. This has been very informative.
Thanks for taking your time, Lisa. I really appreciate it.
That's a wrap for today's episode of One Happy Lawyer, the Estate Planning Podcast. If you'd like to learn more about attorney Dan Krause and his work at Krause Estate Planning and Elder Care Center, visit estateplanningpeople.com. Thanks for listening. Don't forget to like, subscribe, and leave us a review if you'd like. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.